when we spoke of the concept of arrest together with searches and seizures in Article 3, Section 2, I remember mentioning that Article 2 includes or clumps together the idea of privacy of one's home and person to the concept of warrants of arrest, because both of them are subsumed under the general idea of privacy. No, I mentioned that I was having in mind this general concept of what privacy is. Privacy practically is the right to be left alone, or this is the principle of autonomy. My autonomy of my will when I cannot be compelled to, for example, do something which is against my personal decision making, the autonomy to be free from physical restraint, the autonomy from being able to will what I desire to do with my person, my life, my body. So the right to privacy is synonymous to autonomy to decide whether or not to implement certain acts. Okay, that's willingness, no? The act of actuating what you will to do, what you wish to do, or allow themselves to participate in certain affairs. So this is also autonomy relative to personal um, the personal decision to even to be with others, no? To be a social being, to decide to be with others is also a matter of an autonomous decision. We are autonomous because unlike non-sentient and irrational beings, we decide our own direction. We decide our own we have our inclinations emanating from our context, no? But in the end, it is us individually who decide for ourselves. Um, we may have a long discussion about this in philosophy, but the end is the admission that the reason of man, the rationality of man, results to him being naturally a being of freedom. And of course, when you speak of freedom, I can claim my autonomy, no? And I can even assert my autonomy against others. In US jurisprudence, the concept of autonomy in relation to privacy has been even recognized to be among the core necessities or elements of liberty. When you are free from a tyrant's control, no, as a collective community, as a collective entity, the people of a certain nation may be seen to be autonomous in their own way, a nation of autonomy, no? A nation that is not forced by a tyrant, no? When we are free to speak, to express ourselves, to assemble, to organize, that comes from our autonomy to actualize our thoughts or express our thoughts, and to maintain our desire to associate or disassociate ourselves with other people. So privacy is a core necessity in liberty. If you go to definitions of privacy, you have different levels or layers or zones of privacy. You have informational privacy, accessibility privacy, and expressive privacy. Informational privacy refers to your control of information about yourself. We have surrendered too much of our informational privacy nowadays when we even post online matters that are too private, no? We no longer have any regard for personal space. We expose ourselves and make ourselves vulnerable to intrusions because we permit such intrusions when we open the doors for the public to view our personal lives. By doing so, we no longer consider our private life private because we have allowed others to peek into our personal space. We do this when we even uh, make public our personal, family, and relational issues. For example, our information about our our financial status, when we brag about what we have and what we do not have, um, and so on. Accessibility privacy refers to one's, well, it could have many definitions, but the one concrete example of this is your physical proximity, to be physically in control and choose to be away from others or close to others. Expressive privacy is the privacy to express oneself, expressing oneself um, verbally or otherwise, because there is such a thing as a non-verbal expression when we use symbols. Our expression of our ideas is our autonomous expression or manifestation of our thoughts. So these are the theories of privacy, the layers and clusters of privacy that we have. Um, we have tawag nito. We have privacy and autonomy scattered in several provisions in the Constitution. Most of them, or many of them, are in the Bill of Rights. First one is Section 1, when there is this requirement of the due process of law when we speak of our life, liberty, and property. That is autonomy to live our lives, our autonomy of mobility, our autonomy to acquire and maintain property. Okay. You have Section 2, of course, which we already have discussed, no? The privacy of our persons, papers, houses, and effects. Section 6, the liberty of abode and travel, of course. The right of the people, including those employed in the public and private sectors, to organize, to join unions. Section 17, no person shall be compelled to be a witness against himself. No? The autonomy to decide on admitting fault or guilt, no? Or testify against oneself. From the civil code, you have provisions of the civil code requiring all persons to respect each other's dignity, personality, and privacy, and peace of mind. You also have your civil code provisions penalizing by civil liability private or public individuals for violations of your constitutional or fundamental rights relative to your privacy and autonomy. The revised penal code also penalizes crimes involving breaches to your privacy, violations of secrets by a public officer, revelation of trade and industrial secrets, trespass to dwelling. You may say that this speaks of patent and copyright, property rights, but still, this involves privacy. There are also special laws that protect our privacy. The anti-wiretapping law, secrecy of bank deposits, intellectual property code, Data Privacy Act, and the Cybercrime Prevention Act of 2012. The Data Privacy Act and Cybercrime Prevention Act, well, this laws that I have mentioned just now will be subject of your, have been or will be subject of your criminal or civil law, no? Anti-wiretapping, secrecy of bank deposits could be in your commercial law, intellectual property code also. At Data Privacy Act and Cybercrime Prevention Act may be in your criminal law and in your commercial law. This two laws on data and cybercrime is our response to the Budapest Convention. I think the Budapest Convention that consolidates international efforts against cybercrime. In Detainee versus Secretary, going to the privacy as protected by statute, recognizes the zones of privacy, and that this privacy, while protected by law, is subject also to international, is also a subject of international law. Okay. So intrusion is impermissible unless secured or excused by law and in accordance with customary legal processes. Well, that says that our privacy is not absolute. Of course, it is not absolute. No rights are absolute. Okay. No rights are absolute. We live in a world where rights may be restricted in our jurisdiction by virtue of law. They could be given some exceptions, no, our rights. This also recognizes that, of course, mentioning a while ago, that aside from constitutional and statutory basis, we also have the international laws and principles that will protect our privacy from being diminished. We have the Universal Declaration of Human Rights, among others. Okay. The Constitution, of course, protects our this zones of privacy yung mentioned in Detainee, yung the informational privacy, diba? The privacy of our persons as to proximity with others, no? And our privacy of expressing ourselves. These are constitutionally protected as zones of privacy. Primarily, this was recognized in Polio versus Constantino David, which includes the right against unreasonable searches and our privacy of communications and correspondence, among others. Speaking of the privacy of communications and correspondence, this is well protected by Section 3 of Article 3. The privacy of communications and correspondence shall be inviolable, except upon lawful order of the court and when public safety or order requires it. And paragraph 2 thereof mentions of the concept of the fruit of the poisonous tree. Okay. When you speak of privacy, when I give seminars on privacy, the questions usually asked is, can we just take a picture? Well, can we just take pictures of anybody, no, or anything? Can we open computers of our employees in the workplace? Can we claim our privacy in a public space? In US jurisprudence, US versus De Forte, there is among the first origins of this concept of expectation of privacy. The protection in the Constitution as to privacy depends not upon whatever right, property or otherwise, but whether the area was one in which there was a reasonable expectation of freedom from intrusion. Reasonable expectation of privacy means, given the context, the circumstances, can you still claim privacy? Okay. This was in the case of Polio versus Constantino David still, no? For example, office computers. This refers to government office yata. There was an inspection of government computers because of certain possible anomalies, and evidence was derived from some computers from a computer. The question is, can that evidence be used against the individual? Well, evidentiary consequences set aside, was the intrusion legal when you are given a computer in the office, can your employer just open your files? It depends on what files and what data is in the computer. If it refers to your email that is password protected, you cannot open that unless the email is an email by your employer, created by your employer for official use only, with a warning that you should only use it for official use and that he could open the email at any time. There is no reasonable expectation of privacy then because of the caveat. But when you are given a computer, then you are required to put a password, perhaps, and there is no caveat that the computer could be opened at any time. The only possible remedy that the owner has, the establishment has, is the physical ownership of the computer. But as to the data there, depends. If is it an online data, then it still remains as your personal discretion to whether allow intrusion there too. But if the data belongs to the employer, perhaps he could get into that. Reasonable expectation of privacy may also include taking pictures, no, in public spaces, public places. You see Facebook posts of people blurring out plate numbers or faces. Now, if it's a private gathering and they post for a picture with a caveat, popost ko ito sa Facebook later on, there is no reasonable expectation of privacy there because nobody objected. In fact, took pictures with everybody else. No? But if it's a private picture of a private property, taken inside a private property where consent was not been given, there is a reasonable expectation of privacy. What about in the SM parking lot? You do not expect people to just close their eyes when they pass by your vehicle with a plate number. So plate numbers there could be made included in pictures when they take pictures of you and the plate numbers are in the background. Diba? There's no reasonable expectation of privacy there. It's different when the pictures are taken inside a compound of a motel where there are parked cars inside private garages in the motel for clients. That's a different thing. It's a case-to-case basis. Privacy and money laundering, you have RA 9160, the Anti-Money Laundering Act, with the AMLAC, the Money Laundering Council, empowered to do certain things, including get into or look into your bank accounts. The council may inquire into and examine any particular deposit or investment with any banking institution or non-bank financial institution upon the order of a competent court in case of violation of the Anti-Money Laundering Act, Section 11. No? This was questioned in one case, in the case of Republic versus Eugenio, Honorable, Honorable Eugenio. Okay. According to the Supreme Court, because kino-question itong Section 11 of the Anti-Money Laundering Law or Act, the source of right to privacy is as to bank deposits is statutory and not constitutional. The privacy of bank deposits, no? Bank Secrecy Act, is a statute from Congress. Because it comes from Congress, you cannot invoke that law when Congress creates another law, because Congress could always amend or make exceptions to statute by virtue of another statute. And the AMLA is that such a statute that allows for such an exception. Okay. That's part of the plenary powers of Congress. Some cases on privacy, this case of Social Justice Society versus Dangerous Drugs Board and PDEA, this case refers to the mandatory random drug testing for certain groups of persons, students, prisoners here, in this case, politicians, even while the Supreme Court rendered some of the MRDT, the mandatory random drug testing for some groups, it disallowed certain other instances, including as qualification for office. And this one, because this is the drug testing for inmates or prisoners. The essence of a random drug testing is that it is suspicionless and random. When you conduct drug testing for prisoners, the end result will be neither suspicionless or random because they are already facing sentence or cases in court, no? Drug testing in this case would violate the person's right to privacy granted or guaranteed under Section 2 of Article 3 according to the Constitution. The right against unreasonable intrusions to one's person. Even in our school, we have conducted random drug testing pre-pandemic, but we stopped because we have nobody to test during the pandemic times. But definitely we will have the drug testing in the coming school year, including the law school. This case of Gaanan versus Intermediate Appellate Court, this refers to wiretaps. For those young, those very young, some of your homes may no longer have the landlines. Landlines were part of the necessities before the surge of the cell phone technology. We have landlines, one number shared by several extension phones in one house. Somebody listened in to an extension phone. Is that wiretap? According to the Supreme Court, no, it's not a wiretap because the wiretap refers to instruments whose installations or presence cannot be presumed by the other party. Mo na ang wiretap when there is a device that cannot be anticipated. But an extension phone may be anticipated as part of the network of that line in the residence or in an office. So hindi siya wiretap. There's this modern wiretapping technology for listening into private conversations through Yahoo, Facebook Messenger, or through our telco lines. That is possible, but that is also protected by the anti-cybercrime law. You have this case of Zulueta versus CA. We mentioned this. We mentioned that the Supreme Court signaled for spouses that we do not surrender our constitutionally protected rights when we get married. This case of Alejano versus Kabuay refers to the intrusion of the mail matter, the correspondence of prisoners. In this case, this referred to the mutineers, the Oakwood mutineers, whose letters and correspondence were opened and read by those who have them in custody. Sabi ng Supreme Court, the right to privacy of these detained persons are subject to law, as well as the limitations of the inherent unlawful detention of imprisonment. By the very fact of their detention, pre-trial detainees and convicted prisoners have a diminished expectation of privacy rights, especially in this case where the inmates are well-trained soldiers who could coordinate their escape through correspondence. And they have cohorts who are actually also armed and dangerous. The exception here is on the attorney-client privilege if the correspondence referred to mail matter for lawyers, of these people. I remember this case of Ople versus Torres. In the 90s, there was so much ado about a national ID system coming from post-martial law era of Marcos, where people were being politically profiled, enforced to subject of state enforced disappearances, involuntary disappearances, families profiled. No, a network, a national ID could easily profile you, your relationships with other people, your location, your financial status, your social security, and so on, and so on. No? Your loans. You could be profiled politically or otherwise. In the hands of a tyrant, a dictator, or an oppressor, a national ID and its database is information that is really dangerous to hold, no, for a government. That's why the court cautioned that while data may be collected for legitimate use, that sufficient safeguards must be in place to disallow abuses or unlawful peeking or intrusion into such gathered information. And right now, we have discovered that a national ID actually is very useful, especially during the pandemic when the government was distributing aid and ayuda, and money, groceries to people. It could have been a lot easier because what they did was to rely on the barangay to coordinate for them. And sometimes it could allegedly be used for political affiliations. Ang iba hindi na nakakatanggap ng ayuda dahil of political inclinations or disfavor. No? That's the rumors. No? Those are the rumors. But it could be easier if we could have a national ID if we are to transact with government entities. No? Imagine, for many transactions, we are always required a valid ID. A valid ID, by the way, is an ID, no, issued by the state that has your photo and signature. That's a valid ID that we use for notarization of documents, making them public. No. This case of Morfe versus Mutok, I know this couldn't be, but by the way, some of these cases I failed to include, no, but in your syllabus, but you can review this video later on. You can refer to this cases, some of these cases. This refers to SALN. Is SALN a violation of your financial privacy? According to the Supreme Court, hindi naman. Because this is a statute enacted under the police power of the state. It is intended to promote morality in public administration, where public service is always embedded with public trust as an expectation. We will continue with data privacy on the next lecture.